Okay, so I know it took a while for me to bring this video, and I'm really sorry about that. This video is going to be a bit longer than our last video. And this video is going to relate mostly to Commonwealth Caribbean territories that have written constitutions. So I just want to talk about what is going to be covered in this video because, as I said, it's going to be a fairly long video. So we're going to go through the nature and importance of the Constitution, constitutional supremacy, functions of the Constitution, the form and structure of the Constitution, protection of fundamental rights in the Constitution, saving law clauses, changes to the saving law approach, purposive interpretation of the Constitution, due process and the rule of law, the preamble to the Bill of Rights, economic, social, and cultural rights, separation of powers, entrenchment of constitutional provisions, measuring the validity of other legal sources, and how the Constitution validates other legal sources. But first, of course, I'll let you guys to like, subscribe, tell a friend, share our videos, and I love comments. Drop comments below. Tell me what kind of videos you like to see in the future. Ask any questions, any legal questions. I am here to answer. Okay, so let's get started. The written constitution is arguably the most important legal source in the Commonwealth Caribbean. The Constitution is the founding document confirming the independent status of Commonwealth Caribbean territories. The Constitution represents a symbolic break with colonialism and the former British colonial masters. The very act of writing down a constitution is significant. It concretizes the ideals of rights, democracy, and nationhood, and allows for interpretive expansion by attempting to set down the parameters of democratic governance. A constitution also gives life to judicial review, enabling the concept of ultra vires to flourish. The constitution can the constitution can be defined as a body of law containing the rules which determine the structure of the state and its principal organs. It establishes the fundamental principles according to which the state is governed. It is the authority base from which a law is the authority base from which a rule of law originates. Sorry. It is the authority base from which a rule of law originates and derives its validity and further validates other sources. In the case of Colomar versus the Attorney General, it was stated that the Constitution is parent law by which all other laws are measured. They went on to say, in that case, that no one, not even Parliament, can disobey the Constitution with impunity. The Constitution is therefore the ultimate source of power and authority. It is a yardstick by which the validity and authority of law in general are measured. It also governs the exercise of power or authority in the state. The Constitution defines citizens' rights and the shape of both the legal system and the political system. For example, the principles of democracy can be found in Western constitutions, just as the principles of socialism and communism may be found in the constitutions of communist or socialist countries. The Constitution lays down mandatory procedures for government. It is the foundation for judicial review, states basic human rights, including avenues for redress of violations of such rights, and promulgates new remedies. It is also the fountain for procedural fairness or due process of the law. Other functions of the Constitution include the definition of the territory of the state, the creation and establishment of state institutions, and distribution of functions of the state, the granting of authority, and the granting of authority to make laws. Commonwealth Caribbean constitutions contain special mechanisms for change. The typical constitution in the region contains the following chapters or sections: a preamble, chapters on citizenship, a section on fundamental rights and freedoms called the Bill of Rights, chapters defining the powers of the head of state and parliament, chapters defining the powers and the establishment of the executive and judicature, chapters establishing and defining the role and functions of the public service and judicial commissions, chapters on finance. In addition, there's a statutory formula giving Parliament power to make laws for peace, order, and good government. It should be noted that the preamble to the Constitution is basically like an introduction, and it talks generally about rights. All right, the Bill of Rights provisions can be viewed as an attempt to reflect international standards of fundamental human rights as embodied in such international instruments as the European Convention on Human Rights, the United Nations Declaration on Human Rights, and the American Convention on Human Rights. Right, saving law clauses I find is an issue that a lot of law students have understanding. So I'm going to take my time and go through this and try to explain it as basic as I possibly can. So saving law clauses are sometimes called existing law clauses, and they basically attempt to preserve pre-independence law. You will find that a lot of these pre-independence laws at times contradict the rights that the Constitution is just trying to protect. So a lot of saving law clauses may go towards stuff such as mandatory death penalty and that kind of stuff. All saving law clauses are not identical. There are three different types of saving law clauses. There's the general saving law clause, the modification clause, and the partial saving law clause. So let's just go over that real quick. There are three types of saving law clauses. There's the general saving law clause, the partial saving law clause, and the modification clause. So the general saving law clause seeks to preserve all existing law. And these are going to be mostly found in older constitutions in the Commonwealth Caribbean. They're not found in all, they're found mostly in older constitutions. And the purpose of the General Saving Law Clause is to preserve all pre existing laws, so all the laws that were in place before the Constitution was written. The partial savings law clause, these are also called special saving law clauses, and these speak to specific rights. The modification clause allows for the existing laws to be modified so that they're brought into conformity with the Constitution. A question that a lot of people keep asking is if these saving law clauses undermine the creative force of Caribbean constitutions. Because in the past, Commonwealth constitutions have often been interpreted as merely codifying existing common law or statute law, instead of creating new legal rights and indeed new law in general. It is questionable whether the Constitution was intended to be interpreted in such a stagnant and non purposive manner. There have also been the courts have been prepared to revisit entirely their previous generosity towards saving law clauses, which resulted in such narrow interpretations of the constitutions. This more constitution centered approach that the courts are taking has also been seen in some cases involving, well, in mostly cases involving the partial savings law clause. Remember, partial savings law clauses are clauses that speak to specific rights, right? Even modification clauses can be overridden in favor of a clear finding of unconstitutionality. This is not to suggest that the savings law clause is now dysfunctional and will not be considered. Indeed, the value of a saving law clause is not to be denied. Its inclusion was necessary to ensure that there was coherence and certainty in the transition from colony to an independent state. You couldn't just randomly spring a bunch of new laws onto your people. So it was the savings law clauses were seen as a transitional period. Modern interpretations of saving law clauses ensure that the Constitution as a source of law is not only more dynamic but more independent of its common law origins. In the case of Maharaj versus the Attorney General of Trinidad and Tobago, a new remedy in damages for violations of human rights was held to have been created by the Constitution. In Thornhill versus the Attorney General, a new constitutional right to retain counsel was successfully promulgated. In the case of the Attorney General of Trinidad and Tobago versus Whiteman, the Constitution of Trinidad and Tobago was generously interpreted so as to uphold a right to retain and instruct the attorney of one's choice without delay. The grounding principle in these pro-right cases is that a constitution is a unique instrument which must be interpreted in the light of the ideals and principles which ground it. The court should thus give life to the meaning of the Constitution by interpreting it in a broad and purposive manner. The underlying presumption of such an instrument is that the state, through its legislature, intends to secure the broadest spectrum of rights to its citizens. In the case of Sorry about that. Okay, so in the case of Minister of Home Affairs versus Fisher, the Privy Council affirmed that a purposive and generous approach should be adopted in interpreting the Constitution so as to avoid the austerity of tabulated legalism. Sorry, wait, we're not there yet. Right. The norm building and evolutionary character of a constitution was alluded to indirectly in other cases. Commonwealth Caribbean courts seem poised to make the constitutional protection of human rights even more elastic, even in contentious areas such as capital punishment. Yet, while strides toward expansive interpretations of the Bill of Rights may be observed in relation to certain areas, such as the death penalty, or in relation to freedom of expression or the press, our constitutions remain somewhat archaic in other areas. For example, discrimination in relation to sex, gender, and even religion. Okay, so these fundamental concepts, which is the concepts of due process and the rule of law, do not originate from the Constitution, and it's important that you note that. They're simply reaffirmed in the constitutions. Due process arises independently of other rights conferred by the Constitution, so that it is not necessary to invoke it alongside a substantive right. Due process is ultimately a dynamic, even flexible legal concept and seems to redefine itself with changing international standards. The Bill of Rights in a typical Commonwealth constitution contains an introductory clause, which I would have alluded to earlier, the legal status of which has caused much discussion and some litigation. The clause declares that every person is entitled to fundamental rights and freedoms without regard to race, color, creed, political opinion, and sex. The freedoms extended to freedom of expression, assembly, conscience, privacy, and equality before the law. Now, it's important to note that some countries, such as Trinidad and Tobago, do not have a preamble to their Bill of Rights. So, the argument that we're about to discuss does not relate to those territories. Because the Constitution then proceeds to guarantee redress for a violation of human rights as listed under individual sections, other than the introductory clause, there's a line of argument which suggests that only those rights which are specifically mentioned in these individual sections contained in the Constitution are protected. Consequently, where the right is only declared in the introductory clause, it may be interpreted as non-enforceable. This has been the experience in relation to the right to privacy and the protection against discrimination on the grounds of sex. In the case of Gerard and the St. Lucia Teachers Union versus the Attorney General, the court found that no redress was available for a lack of equality on the ground of sex, as it was not mentioned in the Constitution, only in the introductory clause. In the Commonwealth Caribbean, there has been as yet no reversal of the position expressed in Gerard. However, the courts have been slowly stepping toward making the preamble come alive, at least with respect to certain of its provisions. The Privy Council and the Caribbean Court of Justice respectively, have treated the due process or protection of the law provisions in the preambles to the Bill of Rights as not only enforceable but instrumental to the protection of human rights. So we're seeing here that they're picking out certain things out of the preamble to make enforceable instead of stating that the entire preamble should be enforceable. Procedural justice is not to be viewed in the same light as the substantive rights mentioned in the preambles, the latter which must be detailed in the body of the Constitution to have effect. We may observe from what was discussed earlier that the purposive interpretations of the saving law clauses and due process provisions, and by extension the rule of law, appear to be moving away from the internal logic of the Constitution and toward more external expressions of justice. Some may even argue this is merely judicial activism disguised as purposive interpretation. We may well ask, are we hijacking our constitutions? At what point does good judicial decision making become judicial dictatorship, which ignores the legislative imperatives of the democratically elected representatives of the people? Are our constitutions, in particular the Bill of Rights, to be mere reflections of universal human rights instruments and jurisprudence without room for deviation? Is this what the framers of the Constitution intended? Are interpretations of our Constitution, which seem so far removed from their original objectives, any less imperialistic than colonial laws imposed on us? Are such redefined constitutions in sync with coherent governance initiated by sovereign nations? Certainly, a constitution is a document which should embody the particular philosophy and even ideology of the state and its people, even if that ideology appears different to those of other people. Against this must be balanced the need for the Constitution to avoid atrophy, for the Constitution is not a sterile and lifeless document, but an organic and living thing. But we must be careful that in doing this, we do not end up giving the judiciary the power to change the Constitution because they can't make law. They have to interpret the Constitution in the way that Parliament and the writers of the Constitution intended for it to be interpreted. Constitutional protection against violation of rights is secured only against the state. In the absence of ordinary legislation on discrimination and other vulnerable areas involving rights, this emphasis results in a significant lacuna in the law. Moreover, in certain areas of human rights, in particular with respect to discrimination, the Constitution may be seen to be further deficient, either in terms of its silence with regard to certain forms of discrimination, such as sexual orientation, gender, or even sex, or in the weakness of some provisions, or, as we have seen, in the restricted way in which provisions have been interpreted. We may argue further that certain types of rights, in particular economic and social rights, largely rights in the collective, seem poorly served by our constitutions. As such, issues which are vital to developmental concerns, such as rights that should attach to workers and trade unions to enable them to lobby adequately for better standards of living, are poorly defined or entirely absent. We have already seen that the very structure of some of our constitutions can undermine the constitutional instrument as a cohesive and effective machinery for human rights. This occurs, for example, where important rights are mentioned only in the preamble and not detailed in the body of the Constitution, and have been declared unenforceable. Notably, already, vulnerable rights such as discrimination and privacy may also fall into this category. Thus, despite the importance of the Constitution, a number of questions are increasingly being raised about the defects and omissions of Commonwealth Caribbean constitutions, as well as the propensity of the judges to stretch them, sometimes well beyond imaginable or even desirable boundaries in particular subject areas. Not surprisingly, many countries are actively pursuing constitutional reform. One area of constitutional law that is particularly controversial is as it relates to economic, social, and cultural rights. This is the extent to which certain rights, which can be categorized as economic, social, or cultural, are enforceable. These rights, like civil and political rights, may be enshrined in a constitution or international human rights instruments. A common example in the Commonwealth Caribbean is the right to form a trade union. These rights are usually distinguished by the fact that they relate to rights in the collective. This means that they concern not the rights of any particular individual, but a particular class or group of individuals. Further, they often, as the name implies, have significant and obvious economic, social, or cultural implications. Indeed, the factor of cost is one important reason given for their non-enforceability. Other examples of these rights are the right to education, to work, to health, to self-determination, and to strike. The question of the enforceability of these rights has caught the attention of the Caribbean courts with inconsistent results. The implications of the failure to find these rights as enforceable have been felt largely in the area of labor law. While not yet a subject of litigation, the question of whether a trade union could claim a constitutional right to be recognized as the lawful representative of workers in the absence of express promulgation of such a right, but with a constitutional guarantee that workers have a right to form and join a trade union, has also engaged the mind of the public in countries such as Barbados and St. Lucia. The Constitution also embodies the separation of powers principle. This principle goes to the heart of our constitutional inheritance. Indeed, separation based on the rule of law is a characteristic feature of democracies. The principle is of particular significance to the administration of justice in the legal system. The Caribbean courts have affirmed without reservation that the Constitution provides that judges are independent, impartial, and separate from political interference and from the political arm of the government, so as to administer justice impartially. Further, the judiciary and the courts have a monopoly over the exercise of judicial function. Similarly, while the executive can determine a fixed penalty as set by statute, it cannot transfer from the judiciary onto itself a discretion to determine the severity or nature of a penalty. Such a discretion is reserved to the judiciary under the Constitution. Therefore, the Constitution also lays down the parameters not just for the formal sources of law, but also some of its details, such as the authority for the award of penalties. Similarly, the judiciary acknowledged that it does not make law or prescribe legal policy. This is the function of the legislature. Constitutional provisions which secure security of tenure for judges, in particular, by the establishment of independent judicial commissions to appoint and remove judges, also buttresses the independence of the judiciary. All the constitutions in the Commonwealth Caribbean contain provisions for entrenchment, whereby certain of their provisions may not be altered except by special majority of Parliament or in some cases a referendum. This confirms the special nature of the Constitution, placing it in a different category to that of ordinary legislation. In the case of Hines versus R, the court noted the significance of this entrenchment. They stated, the purpose served by this machinery for entrenching is to ensure that those provisions which were regarded as important safeguards by political parties should not be altered without mature consideration by the Parliament and the consent of a larger proportion of its members than the bare majority required for ordinary laws. A significant contribution of the Constitution to the development of the legal system is its role in testing the validity of other laws and legal sources. Therefore, the Constitution is the cornerstone of the rule of law. This testing or measuring of other laws and legal sources is carried out by the process of judicial review. The judicial review process is most important in determining the validity of ordinary legislation. Such legislation may be measured against constitutional norms and declared unconstitutional or ultra vires if it offends these norms. The High Court has been assigned this role of of judicial review. This judicial review role is a responsibility which the courts must not shirk from or attempt to shift to Parliament. In the case of Commonwealth versus the Attorney General, Justice Wood instead referred to the Supreme Court as the guardian of the Constitution. Where legislation is found to be in conformity with the Constitution, it is said to be intra vires. The concept of ultra vires, or conversely intra vires, are crucial to an understanding of how the Constitution can invalidate or legitimize ordinary legislation as a legal source. If legislation does not conform to the general principles protected by the Constitution, it will be declared null and void and be struck off the law books. Therefore, the Constitution presents a formidable challenge to legislation. The challenge to legislation under the ultra vires principle is not only the prerogative of a citizen as against the state, rather, the state itself can challenge and therefore test its own legislation in the courts. The legislation may have been promulgated by a previous government which had different policy objectives. The Constitution also validates other legal sources in a sense other than the intra vires concept discussed, since it gives Parliament and the legislature the authority to make law. Legislation ultimately owes its legitimacy to the Constitution. Similarly, the power given to the state to sign international treaties is found in the Constitution. Hence, the legal source of international law can be said to be validated by the Constitution. Even the authority given to the common law in the independent Commonwealth Caribbean nations can be traced to the Constitution, as it saves the common law recognizing as applicable law in the legal system. The Constitution is therefore of prime importance in defining and shaping legal sources and ultimately the legal system in the region. Okay, so I know that this video has been longer than the last video, so I just want to thank you guys for staying with me and watching the full thing. Our next video is going to be on judicial precedent and the common law as a source of law. That video may also be a lengthy video, so come prepared to take notes and to stick with me all the way through. Thank you so much for watching and stay tuned for the next video in this series.